The right-wing United States Supreme Court strikes again, reaching a major decision, a 6-3 decision authored by Justice Clarence Thomas, and the right-wingers on the Supreme Court just struck down a federal ban on bump stocks, holding that it is not authorized by an existing statute from 1986, which bans the use of machine guns. Again, this was a 6-3 decision. Clarence Thomas authored it. Let me read for you what Clarence Thomas said. Let me also explain to you, though, why this ruling betrays any claim that these right-wing Supreme Court justices have, that they follow the strict text of statutes. Because if you look at the strict text of the statute for the machine gun regulation, you will find that bump stocks, while not invented in 1986, are clearly included in that ban from 1986. Well, Justice Thomas, delivering the opinion of the court, says Congress has long restricted access to machine guns, a category of firearms defined by the ability to shoot automatically more than one shot by a single function of the trigger. 26 U.S.C. Section 5845B. See also a similar section. Semi-automatic firearms, which require shooters to re-engage the trigger for every shot, are not machine guns. This case asks whether a bump stock, an accessory for a semi-automatic rifle that allows the shooter to rapidly re-engage the trigger and therefore achieve a high rate of fire, converts a rifle into a machine gun. We hold that it does not, and therefore affirm. Again, there was a blistering dissent by Justice Sotomayor, who says that this will place American citizens in grave peril. And remember, the ATF instituted this bump stock ban following the Las Vegas shooting, where the shooter who fired the thousands of rounds relied on bump stocks in order to have the frequency of that horrific killing spree. Katie Fang puts the question this way as well. The question in this case, Garland versus Cargill was the case's name, is whether a bump stock, an accessory for a semi-automatic rifle that allows the shooter to rapidly re-engage the trigger to fire very quickly, converts the rifle into a machine gun. The Supreme Court holds that it does not. So, okay, let's take a look at the plain text of the machine gun ban from 1986 that's at issue, found in 26 U.S. Code Section 5845. The definition of machine gun as part of that ban was the following. The term machine gun means any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. The term shall also include the frame or receiver of any such weapon, comma, any part designed and intended solely and exclusively, or combination of parts designed and intended for use in converting a weapon into a machine gun, and any combination of parts from which a machine gun can be assembled if such parts are in the possession or under the control of a person. So an accessory for a semi-automatic rifle that basically converts it into the same thing as a machine gun would seem to be precisely what Congress was legislating, because Congress didn't know all of the potential future things that could be invented in the future. Bump stocks were invented in the early 2000s, so Congress couldn't call it out by name, but it called it out by structure in a very strict textual way. As Aaron Frischner puts it, I don't know how the plain text of the law could possibly have been made clearer to ban a bump stock or any other device that does precisely what a bump stock does, for the reasons that I just read to all of you. Mark Joseph Stern, a legal analyst for Slate, says, correct, the only way to carve out a loophole for bump stocks under the federal ban is to torture the words of the statute until they mean something different from the plain text, which is exactly what the Supreme Court just did. Going to this Washington Post article, which describes how the Supreme Court strikes down the federal ban on bump stock devices. The case focused on whether bump stocks qualify as machine guns under a law that bars civilians from owning such weapons. Notice the framing, though, here by the Washington Post. It says, a divided Supreme Court on Friday struck down a federal ban on bump stock devices that allow semi-automatic rifles to fire hundreds of bullets a minute, upending one of the few recent efforts by the federal government to address the nation's epidemic of gun violence. The way they frame it, though, a divided Supreme Court. It's a 6-3 decision. The 6 right-wing Supreme Court justices, who were all appointed by Republican administrations, struck down the ban. They said bump stocks, weapons of mass destruction in any type of situation, all good. All good. It was the Democratic appointed justices, led by Justice Sotomayor in the dissent, but joined by Justice Kagan and Justice Ketanji Brown Jackson, who said, no, let's be very clear. From the strict text of the regulation that was passed in 1986 regarding machine gun and the parts that convert things into machine gun-like devices, Congress had already specifically legislated in this area, and the ATF, which then imposed the regulations, was well within their right to do so, as an agency is permitted to do in the safety and interest of the American population. But what the Supreme Court justices on the right wing said is, nope, what really needs to happen here is that Congress must specifically pass a law that uses the exact word bump stock. So in order for us to have safety regulations, Congress has to take a time machine and go into the future. They need to predict the name of every specific device in the future, and then they have to do that in the past. Otherwise, Congress has to go, and by the way, our Congress right now, run by MAGA Republicans who show up in front of the criminal courts where Donald Trump's being prosecuted, where Trump dresses them up in long red ties or in ties that have Trump's face on it. You think they're going to legislate and pass a law that prohibits bump stocks? Donald Trump's out there bragging that the NRA at NRA conventions, that he does nothing and that he's going to give them everything they want. You think that the Trump cult Congress, controlled right now in the House by MAGA Republicans, are going to engage in any type of legislation like this? That's why Congress legislated in '86 to deal with these types of issues, to create a safer country. But the Republicans keep on butchering all of these ways to try to keep our country safer. The article goes on to say the 6-3 ruling continues they say conservative, I'm going to say the MAGA Republican majority's record of limiting gun restrictions, most notably in a landmark 2022 ruling that has made it easier to challenge modern gun control laws. So what we should say is the right-wing majority's record of trying to have us all live in their dystopian American carnage hellscape. I mean, what is it that they're trying to accomplish here other than force us to live in their horrific, horrific dystopia? Remember again, the bump stock ban was in response to the Vegas shooting, to address something very specific. And in her dissent, Justice Sonia Sotomayor said the majority's opinion would have deadly consequences, adding that the court hamstrings the government's effort to keep machine guns from gunmen like the Las Vegas shooter. And just so you know how this lawsuit originated, someone named Michael Cargill, a U.S. Army veteran who owns a gun shop in Austin, supported by the gun lobbies, filed to block the regulations by the ATF. It worked its way up to the right-wing Supreme Court, and here's what they did. One final observation to make for you. amidst all of the discoveries of Justice Clarence Thomas's corruption, literally being bribed $4 million plus, causing the Supreme Court to have a massive crisis of credibility with the American people. It's up to the Chief Justice to assign who writes the opinions here. So we know that Clarence Thomas is quite literally bought and paid for by the gun lobby and by billionaires and he does what they tell him to do. So with all of that knowledge, we have Justice John Roberts, who's the Chief Justice, and he could assign who's going to write this opinion. He could write this opinion. He could have Gorsuch write this opinion, Kavanaugh write this opinion, Amy Coney Barrett write this opinion. He has Justice Clarence Thomas, amidst all of this, write the decision to say that bump stocks should be freely sold. There should be no bans. What bigger FU can you give to the American people than that? Just think about it from 30,000 feet up. How insane that is. How dangerous that is. It's why voting's important. It's why elections have consequences. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. Let's get to 3 million subscribers together. Thank you so much for watching. Have a wonderful day.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.